Hello friends, I'm CA Rashmi Kaur. We have decided to have a discussion on this forum regarding Supreme Court orders on extension of limitation period. We have with us CA Malik Girish Anand, having 28 years of experience, CA Pradeep Singh, and CA finalist Abhay Pratap. Now, I will request Mr. Girish Anand Malik to elaborate further on this topic of extension of limitation period. Yes.
Hi guys, we are passing through a very tough period due to the second wave of COVID-19. We are all trying to sail through this tough period, and we have to really applaud the efforts of doctors and health workers. And everybody has been applauding their efforts, thinking that they are the ones who are going to take us through in this difficult period. However, nobody is applauding the efforts of judiciary, which have also done a fantastic job, in my opinion, in order to watch the interest of Indian citizens. Supreme Court, it has come out with various, with plethora of judgments wherein it has helped the Indian citizens. They have, pulled up the central government and state government for scarcity in oxygen and medicines during this pandemic. They have also pulled up the schools for charging exorbitant fees, which they are not supposed to charge, as very less of their infrastructure is being used. And last but not the least, they have come out with the judgment on extension of limitation period. They have, in response to a writ petition filed, they have come out with the suo moto writ petition order 3/2000, dated 23rd of March 2020, in which they have said that the limitation period shall get extended for filing various appeals, applications, litigations, and all other proceedings under the general and special laws, whether condonable or not. This judgment has come into effect from 15th of March 2020. Any questions on this?
Yes, sir. As you explained, the first order of Supreme Court on limitation period, which was passed on 23rd of March 2020. Right. So, does it sustain today also?
Basically, another order was passed by the Honourable Supreme Court on 8th of March 2021. This said, looking at the pandemic situation, as the number of cases, they had considerably moved down, things had started coming back to normalcy, and offices had started working and they had become fully operational. They said that we are passing an order in which we are ending the order dated 23rd of March 2020. So in that order, they said the limitation period as envisaged in our original order shall start from 15th of March 2020 and it shall end on 14th of March 2021. So this is the position as per the second order of the Honorable Supreme Court.
So now how will you calculate the limitation period subsequent to second order passed on 8th of March 2021?
Yeah. After the order which has been passed on 8th of March 2021, the limitation period now starts from 15th of March 2021, and you have to add another 90 days to that period to file appeal under any act, whether under general law, special law, any particular act. You have to just calculate the period of 90 days from that date.
So what is the situation right now? Is there any addition to the previous order or the same has been continuing?
Yeah, since the Supreme Court order dated 8th March 2020, brought the original order dated 20th March 2020 to an end. Therefore, then there was an outbreak of COVID cases again, which is technically called the second wave of COVID. So, Advocate on Record Supreme Court Association, they filed a writ under the same writ number 3/2000, wherein they requested the Honourable Supreme Court to take cognizance of this situation and extend that period of limitation. Subsequent to this particular petition filed by Advocates on Record Association, the Supreme Court has on 27th of April 2021 further extended the limitation period, and they said in that particular order which they passed on 27th of April 2021 that the original order dated 20th of March 2020 has got extended. They have restored the original order. In that particular order, they have used two more phrases, which are judicial cases and quasi judicial cases. Any questions on this?
So, yes, sir. One more question on this. That what is the difference between judicial and quasi judicial proceedings?
The judicial proceedings, judicial proceedings are generally held in Supreme Court, High Court, and district courts. In these proceedings, all the rules pertaining to the Indian Evidence Act have to be followed. Under the cases of civil cases, CPC has to be followed, and in case of criminal cases, CRPC rules have to be followed. The word quasi judicial means something which is partial or incomplete. That means the General Evidence Act rules are not followed in these cases, in the quasi judicial proceedings, and they generally do not give prosecution orders, means they don't give any caging orders to the people. So, and the authorities which are undertaking quasi judicial proceedings in India are appellate tribunals, revenue courts, and some other lower courts, wherein these quasi judicial proceedings are taking place.
So, whether these quasi judicial proceedings cases will be covered from the period of first order or from the period of second order?
Yes, this is a very good question. Basically, I am of the opinion, since the order dated 27th of April 2021 has restored the original order dated 23rd of March 2020, and it is just giving an explanation. It's just adding an explanation that quasi judicial cases and judicial cases both have to be included. So, in my opinion, this order applies, that this order of extension of limitation, it applies to judicial and quasi judicial cases from 15th of March 2020 itself. It's not an addition, it's a mere explanation. Since the original order has been restored, they have just added an explanation, and in my opinion, this explanation is applicable from 15th of March 2020 itself. Any other questions?
Sir, I have some questions. First of all, I would like to thank you for such initiative taken by you to enhance the clarity about the Supreme Court order. However, I have some questions on this. Sir, can you clarify? You said about the exclusion of time limit of proceedings. So, will this time limit applicable to the AO or only for the assessee?
No, in my opinion, any order passed by any court, whether it is Supreme Court, High Court, or a lower court, has to be equitable for the assessee as well as for the government. So, in my opinion, this applies not only to the government, to the assessee, it applies to the government authority as well. This means that in case we get the benefit of extended period of limitation as assessees, the government has also, full right to avail that extended period of limitation in case they have missed out on something.
Okay, sir. If sir, I have another question. If in case it will also beneficial to the assessee, you can you please point out some specific benefit available to the assessee under Income Tax Act?
Yeah. Now, since quasi judicial proceedings, they have been taken into the ambit by that order, that means that revenue authorities have also come into picture. So, I'll give you an illustrative list of the benefits which the assessees can derive out of this order under the provisions of Income Tax Act. but I'll give a disclaimer that this is an illustrative list. It is not an exhaustive list. This list is being given basis my experience in a practice as chartered accountant, and other cases might be there. And this is a forum which is open for discussion by everybody. So, the first thing, in case of assessments under section 143(3) of Income Tax Act 1961, once an order is passed, the assessee gets a time period of 30 days to file an appeal in case the assessee is aggrieved by that order. Now, in case your assessment order was passed around, say, 15th of March 2020, and the limitation period, it has not expired by 15th of March 2020, but till date you haven't filed an appeal, what I'll suggest is you guys can take the benefit of extended period of limitation and file your appeal today. Nobody can stop you from doing that. The second case is in case, an adverse assessment order has been raised against the assessee under provisions of TDS, and the period for filing of appeal has gone away, it has expired. You can still take the benefit of the extended period of limitation, provided the extended period of limitation did not expire till 15th of March 2020. So in case of TDS orders also, you can file an appeal. And it's not just the case of appeal with the first appellate authority. This order of extension of limitation period should apply to high courts, supreme courts, and appellate tribunals also, in my opinion. The third case is, in case an assessee receives a notice under section 148 of Income Tax Act 1961, he is given generally 30 days time to file his income tax return in response to this notice. Now, hypothetically, suppose this period of 30 days or the extended period has already expired, you guys can still take the benefit of extended period of limitation as provided by the appellate order. And the fourth case, where the assessees can take the benefit of extended period of limitation is under section 154 of Income Tax Act 1961, wherein assessee can file an application of rectification in respect of the mistakes apparent from record. There's a time period of 4 years from the end of the financial year to which this application for rectification relates. Now, in case you guys could not file your application under section 154, you can always take the benefit of extended period of limitation as provided by this Supreme Court judgment, and you guys can still file an appeal. I think nobody is going to stop you, and that appeal would be entertainable, in my opinion. Any more questions?
Yes, sir. To be more specific, how can the assessee take benefit of this order under GST?
Yeah. Now I'll give you an illustrative list of the various provisions of GST where the assessee can obtain benefits. Again, I'll give a disclaimer that this is just an illustrative list and not exhaustive list. There may be some other cases also based on the experience of other professionals. Now, the first case is, in some cases, GST authorities, they have cancelled the registration of dealers for not filing GST returns within the right time. And in some cases, they have, cancelled the registration because they have filed the returns on delayed basis. In case your registration has been cancelled due to any of these reasons, suo motu by the GST department, you guys have right to file the appeal against such cancellation orders even today, provided your period of limitation. It's worthwhile to point out that there's a 90-day limitation period under GST Act for filing of appeal, and it can be condoned by 30 days, in case you file application for condonation of delay and the GST authorities feel that it is condonable. Now here, the point is, in case 90 days period was remaining as on, limitation period had not expired before 15th of March 2020, you guys have the right to file an appeal today also. The second case where you can file appeal till today also is the case where you guys had filed for I'll say for cancellation of registration yourself, for the surrender of your GST numbers. The assessing officer or the GST authorities, they have to pass an order for cancellation of registration within 90 days of receipt of such application. Now, there have been many cases where the registrations have been cancelled by the GST authorities, and they have given some stipulated date before which you had to file GSTR 10, and many assesses could not file GSTR 10. There is a penalty of 200 rupees per day for delay in filing of GSTR 10, and there is no upper limit to that penalty. So in case the penalty has become a substantial amount today, you have the right to file an appeal against the this penalty which is being imposable, and that appeal will be entertained under the extended period of limitation. The third point in regard to the benefits under GST is pertaining to the GST refunds. In case of refund for input tax paid in respect of export of goods and services, there's a time lag of 2 years from the relevant date to apply for RFD 01 to claim refund in respect of GST paid for on input services for export of goods or of services. So there are cases, wherein the assessees could not file either RFD 1 on or before, 15th of March 2020, where, and in cases the limitation period to file refund application under GST expired, after 15th of March 2020, you guys can still file RFD 01 to claim your refund, and you can give, the extended period of limitation that it was barred because of, pandemic, and the Supreme Court has allowed that. And the fourth case, where GST assessors can take help is, everybody knows that there is no assessment under GST, and all the returns filed by the assessors, they are cases of self-assessment only. So in cases of self-assessment, you have a right to file an appeal against the GSTR 1 or GSTR 3B filed by you, and nobody can stop you from filing an appeal. So in case you file, find that, you have any adverse thing to arise from the GST returns filed by you from March 2020 onwards, you have got the benefit of extended period of limitation, and you can file those appeals in case you are expecting any kind of adverse orders against such returns by the GST department. I'll give you another instance in which my opinion becomes an appealable order taking the benefit of the extended period of limitation. There have been cases wherein people have claimed refund of input credit, but the selling dealers, they haven't filed the proper documents to entitle them to claim the refund, and it's not appearing on the GST portals of our clients. In such cases, the clients had no other option but to forego this input credit, even though they held proper tax invoices in respect of these purchases or inputs made by them, and they had made the payments through their bank accounts. But since they had foregone this benefit for the simple reason that this input credit was not appearing on the GST portal till 30th of September 2020, which was the last date to claim the input credit in respect of financial year 1920, we strongly recommend that in all such cases, the assessors, they should file an appeal, and they should say that this input credit should be made available to them due to the extended period of limitation. And I think GST authorities will have to look into that. Besides doing this, they can take benefit of two very important judicial pronouncements. One is the case of KK Industries, this is a Supreme Court case, and another judgment they can quote is Arise India, which is a High Court case. These cases have really, gone in favor of the purchasing dealers. They say in case a purchasing dealer is unable to avail the input credit of tax paid by them, and there is no fault of the purchasing dealer. It is solely on account of fault of the selling dealer, as he has not filed either taxes in time, or he has not submitted the requisite forms to enable the flow of input credit to the purchasing dealer. They have to demand this tax from the purchasing dealer, and the selling dealer from the selling dealer, and the purchasing dealer should not be penalized for that. So I think these are 5 or 6 instances where the GST, under GST, the benefit is available to all the assesses. And I think all the professionals should take note of these things. Any further questions?
No, sir, I would like to say something. As you already cover almost each and every aspects of this order, however, I would like to request you to give some suggestion to our viewer according to your experience in the field.
Yeah, Abhay, what I feel at this point of time is there used to be a time when all the professionals used to play around with the date of service of notice. They used to say the notice has not been served on the assessee, even though income tax authorities or any other authority for that matter, GST or service tax, they have, sent the notice through registered court within the stipulated time frame to issue that notice. But everybody was able to play around and say, since this particular notice was not served on the assessee within the stipulated time frame, the assessment proceedings in pursuance of such invalid notice have to be quashed. And it was done in many cases. But now, since everything is done online and everything is filed online, and even assessments are being done online as e-assessments, there is no escape for the professionals or the dealers. So what is happening now is GST authorities, they just put a notice on the portal. Now you don't need that notice to be served. It is deemed to be served from the date on which it is coming on the portal. So we cannot play around in that case, as we used to play previously. So what I'll recommend is all the CAs, all the tax practitioners and other professionals in this profession, they should log in to the GST portals of all their clients at least 3 times in a month to ensure that there are no unattended notices or there are no assessment orders which need to be appealed against. So why I am saying 3 times in a month is because generally there is a time period of 15 days to reply to each and every notice which is received from the GST authorities. And nobody, at least not in our firm, there is a practice of logging in just to check the notices and to check the assessment orders, whether they have been received or not. So in case all the professionals make it an exercise to do it on a 10-day basis, because generally we log into the GST portal just twice. One is to file GSTR 3B, and second time to file, first time to file GSTR 1 and second time to file GSTR 3B. And that too, maybe it is done by articles or lower level clerks. So any person who is having the knowledge of GST law, or he or she should be given specific instructions to log into the portal 3 times at least in a month to ensure that either there are no unattended notices, or in case there are some assessment orders which have been passed by the GST department. Obviously, they are going to be adverse orders only in case government is passing them on their own. Sir. So, you should file appeal against those orders. You will file only when you come to know about it. Suppose 90 days period to file the appeal and even the 30 days condonation period is gone. You cannot do anything. Even you cannot file a writ in High Court and Supreme Court to have that period extended further. There are more judicial pronouncements on this also, but that I am not giving right now. So, basis my experience, my suggestion is to log into the GST portal at least 3 times in a month to ensure, and why this discussion assumes more importance at this point of time. It is simply because since 15th of March 2020 till date, there will be many orders which are pending, and against which we can file appeals under the extended period of limitation. Are there any further questions?
No, sir.
Okay.
Thank you.
Now,
Thank you so much.
I'll feel that this discussion has been important for everybody, and since we are passing through a tough time, please move out of your residences when it is very important to do so, and move out with the double mask. Thank you, and hope you found the discussions good. And we are also uploading these 3 Supreme Court judgments, by way of link to this discussion, so that it can be easily accessed by everybody. Thank you and goodbye.
Thank you.
Goodbye.